Our next presenter has worked as a lawyer, politician and departmental chief executive in the Northern Territory, which was her home for about 25 years after graduating from the University of Melbourne. She's also worked as a consultant, conducting a review of the Territory's youth justice system. After the South Australian election in 2018, she was appointed Chief of Staff to the Honourable Vicky Chapman MP, Deputy Premier and Attorney General, the first woman in South Australia to serve in both of these roles. In April this year, she was appointed South Australia's Commissioner for Equal Opportunity. Please welcome Commissioner Jodeen Carney.
Good morning and thank you, Tracy. Following Kate Jenkins is always a difficult act to follow, of course, but I will do my best. Thank you for the opportunity to participate today to talk about the review that my office undertook early in 2021 into harassment in the South Australian legal profession. It's important for me, at least, to note at the outset that the review preceded my appointment. It was undertaken by the former Acting Commissioner, Steph Halliday, and her team. And of course, I am the beneficiary of the great work that they've done. Prior to discussing some of the key issues that arose from the review, I thought it sensible to provide a short overview of the South Australian Act and indeed my role. I know that many of you work health and safety professionals, and you know that Australia's health and safety laws are largely harmonised. The same cannot be said about the equal opportunity and anti-discrimination laws. Each state and territory has its own equal opportunity laws which work concurrently or complement Commonwealth legislation. And while they all seek to achieve the same objectives, their scope and reach differ. And I'm raising this because in my presentation I will be talking about the South Australian Act, so it's important that you note that the laws will differ slightly in each jurisdiction. South Australia's Equal Opportunity Act provides protection, as you would expect, against discrimination, victimisation, sexual harassment in a broad range of areas of public life. It commenced in 1984 with the stated intention, and I'll quote from Parliament's Hansard, of giving each and every person a basis on which they can live their life in dignity and inequality and with the respect that is due to every single person in the community. A worthy statement. In addition to generally administering the Act, which predominantly for us includes dealing with complaints that are lodged in our office, I perform two key roles as Commissioner. I must foster and encourage among members of the public unprejudiced attitudes with a view to eliminating discrimination. And I may and can make recommendations to my Minister, who's the Attorney General, for whom I used to work, about reforms that further the Act's objectives. That work is ongoing. Under our Equal Opportunity Act, it's unlawful to treat people unfairly on a number of grounds, such as sex, disability, age, etc., in a total of 8 areas of public life, which includes the provision of goods and services, education, accommodation, and most notably for today's purposes, employment. The largest area of complaints that my office receives is about employment across all grounds of discrimination. In fact, our complaints with respect to employment represent nearly half of the complaints we receive. In this state, it is unlawful for a person to sexually harass another with whom he or she works. Unlawful sexual harassment is defined as, and I quote, an unwelcome sexual advance of a sexual nature or an unwelcome request for sexual favours or unwelcome conduct of a sexual nature in circumstances where it is reasonable to expect that the other person would be offended, afraid, or humiliated by that conduct, end quote. There's a significant difference between the Equal Opportunity Act and work health and safety laws regarding the obligations for employers, certainly in this state. Work health and safety laws provide, as you well know, a positive duty on employers to prevent or minimise workplace risks, such as those arising out of the workplace sexual harassment. And Kate has talked about some of those effects. In contrast, under the equal opportunity laws, employers and regulators are not required to take positive or proactive steps to prevent sexual harassment in the workplace. No positive duty exists. I understand, however, that the Parliament will shortly consider enacting or amending legislation to impose a positive duty, and I'm very pleased about that. An employer's liability in this state for sexual harassment at present can only be found when they were made aware of specific circumstances in which an employee was subjected to sexual harassment and failed to take reasonable steps to prevent it happening, and if they are vicariously liable for the actions of their employee. An employer's liability does not arise until an unlawful act has occurred. So put another way, there needs to be a victim, and the burden rests solely on the individual to make a complaint. I'm hopeful that that will change. This was the framework that existed at the time the review was undertaken in this state, which was late 2020 and early 2021. So far it's not changed, but as I've alluded to, it might. The review came about following revelations in the High Court that many of you will remember regarding the conduct of former Justice Dyson Heydon, and that was in June 2020. Interestingly, you will also recall, I think, that there was a further shift in the national conversation about sexual harassment 8 months later, when allegations became public in respect of behaviours at Parliament House in Canberra. Those legal and political institutions make and administer the laws by which the rest of society functions. So reviews and changes were required, indeed demanded, and rightly so. Following a motion passed in the upper house of the South Australian Parliament in October 2020, the State's Attorney General appointed the then acting Commissioner for Equal Opportunity to conduct the review, and the report was delivered in April this year. To further refresh your memories, the revelations about former Justice Heydon comprised an independent investigation that was commissioned by the High Court that found that 6 women associates were sexually harassed by him, claims he continues to deny. The High Court sits at the apex, obviously, of the Australian judicial system, and its justices are the most preeminent legal minds in the country. For many, but for lawyers in particular, these revelations were disheartening and astonishing, and there was a groundswell of support for greater scrutiny across the legal profession, which is why the Parliament resolved that an inquiry in this state should be undertaken into the prevalence of harassment in the profession, including sexual harassment, and wanted my office to consider the adequacy of laws and processes for making complaints about harassment and sexual harassment. It's worth highlighting that in January 2020, Kate delivered her report to government. Criticism, fairly in my view, has been levelled at the federal government for not acting immediately or quickly enough on the report. But politicians and bureaucrats around the country knew of its existence and the issues it canvassed. I believe that also added to the momentum for the review that my office undertook. Interestingly, I guess not surprisingly, key themes in the respective work report were mirrored in our review. Kate identified that sexual harassment is more likely in the workplace where other forms of incivility are able to prevail, such as bullying and harassment. She also found a greater risk of sexual harassment in workplace settings that have an overrepresentation of men in senior leadership roles, that are organised according to hierarchical structures, that have significant power imbalances and have a highly competitive nature or culture. These hallmarks, of course, have been long ingrained in the legal profession. Not only do these factors allow sexual harassment to flourish, but they also create an environment in which there are many barriers that will prevent or deter victims and bystanders from reporting it. Kate's report was a valuable resource to the review undertaken by my office, and it continues to be a valuable resource, I think, for all Australians. I'd like to make some additional points and observations about the legal profession and factors unique to it that have the potential to increase the risk of sexual harassment. Currently in South Australia, there are more women solicitors, 53%, than male solicitors, 47%. This is consistent with all states and territories, but significant, particularly significant in South Australia, where there are almost 2 women solicitors for every male solicitor in corporate legal practice. And I think that will surprise some of you. But despite this, there's still a clear deficit in women in senior roles and positions of authority, which creates an environment where power imbalances thrive. The profession, of course, doesn't just comprise lawyers. There's thousands of support staff, and many of those are women. The legal profession has a strongly entrenched hierarchical structure. Members of the judiciary, judges, magistrates, tribunal members, they sit at the top. Then there's senior barristers, junior barristers, partners, associates, solicitors, paralegals, clerks, and admin people. It's a long list. For lawyers, particularly young lawyers, they know that decisions they make are likely to shape their careers from an early stage. So whether they report something, whether they don't, is likely to be more important to someone new in the profession than perhaps more senior. So young lawyers are the most vulnerable. Students and recent graduates often work unpaid to advance themselves. Many seek out unpaid internships, summer clerkships, and undertake voluntary work at student-run law centres. And it creates a situation where the most junior members of the profession are often working with those who have the most power. Judges' associates, and these were the ones who made the reports in respect of former Justice Hayden, work in judges' chambers with few others, which can lead to unreasonable expectations and disrespectful behaviour, which can easily go unchecked, and it's well known. For many young people are ill-equipped to complain. Others are simply too afraid to do so because they are concerned it will ruin their careers. And this power imbalance exists in most legal workplaces. In private practice, the senior practitioners are usually the partners, and there's a widespread view that no one will make a complaint about a person whose name is on the building. However, it would be a mistake to believe that it's only young people who are subjected to sexual harassment. The investigation into former Justice Hayden revealed a pattern of predatory sexual conduct, not just to young associates, but also towards more senior barristers and prominent lawyers. His conduct was reportedly an open secret, perpetuated by a culture of silence and tolerance towards disrespectful and unconscionable behaviour by a powerful man. And this culture defined the profession for many years and was tolerated by many who thought that it needed to in order for them to succeed. And it's this culture that we all need to change. So now turning to the review that the former acting commissioner undertook, she and her team commenced the review sensibly. They approached all current and former members of the South Australian profession in the state, including judicial officers, practitioners and support staff. Participation was widely promoted. An anonymous online survey was completed by 600 participants. They undertook 16 interviews and received 18 written submissions, and most of those submissions were from victims of sexual harassment or sexual assault in the profession. I should note that the review was into harassment in the legal profession, which included discriminatory harassment, unfavourable discrimination or offensive behaviour on the basis of age, sex, disability, race, gender identity, sexual orientation, caring responsibilities and pregnancy. It was not confined to sexual harassment, although obviously I will focus on that today, but in any event, sexual harassment was the most significant area of complaint that came through the review. Let me go through some of the findings. The review revealed that more than 40% of the survey respondents had experienced sexual harassment while working in the profession. Nearly 60% of women had experienced sexual harassment compared to 10% of men. The most common types of sexual harassment included sexually suggestive comments or jokes, inappropriate leering and close contact, intrusive questions about physical appearance and private matters, and inappropriate touching, kissing and hugging. Repeated requests to go on dates, requests or pressure for sex and other intimate acts were also common. Worryingly too was the use of email and social networking applications to share inappropriate images and messages, which was common outside of work hours and away from the office. Almost 3/4 of those who had been sexually harassed had experienced it in an office or other workplace, and more than half had experienced it at a work event. One incident occurred at an after-work event where the victim, a university student completing work experience, was cornered in a bathroom by the male harasser who was senior in the profession. The harasser exposed his genitals to this young woman, pushed them towards her face and told her to suck on it. 10% of victims had experienced sexual harassment during legal proceedings, during a case. One recounted sitting in a courtroom and receiving inappropriate sexualised text messages from a magistrate. The same magistrate who was at the time presiding over the very courtroom she was in. He was expressing a sexual fantasy involving her as if it were occurring right there and then in the courtroom. 80% of victims identified their harasser as being a person more senior to them in the workplace. For around a quarter, it was their direct line manager. About a third had been sexually harassed, that is of the survey participants. About a third had been sexually harassed by a third party external to their business, such as a client of their firm, opposing counsel and so on. More than 10% of those said that they'd been sexually harassed by a current or former judicial officer. 70% of sexual harassment victims had never reported it. Even within the confines of a confidential survey, 32% of those who participated preferred not to say how they had been sexually harassed. They were concerned about being found out and concerned about risks to their careers. And some of the reasons for not reporting harassment included a lack of understanding and trust in complaint processes, fear of repercussions on career and work life, and the culture, put simply, of not rocking the boat. Existing complaint mechanisms in the profession include bodies such as the Legal Profession Complaint Commissioner and the Law Society. But reporting harassment required the complainant to be identified, and the processes were more often than not adversarial, given what was at stake for the alleged harasser. So from an early stage of making complaint, many victims felt that they were not believed, those who were brave enough to make a complaint, and others simply didn't have confidence in the complaint process. As the former acting commissioner wrote in her excellent report, and I quote, "Awareness is not the problem. Fear of speaking up is the dominant constraint," end quote. The report made 16 recommendations. I don't propose to go through all of them. I'll just run through the main ones. And that is that the Attorney General consider amending the Equal Opportunity Act to impose a positive duty upon employers to eliminate discrimination, sexual harassment, victimisation, that legal workplaces that deliver continuing professional development courses deliver one course each year for the next 5 years with respect to bullying, discrimination and harassment, that judicial officers undergo training on the nature, driver and impacts of harassment, including sexual harassment, and that the state's universities and providers of practical legal training education, legal training, review their ethics content with a view to providing profession-specific perspectives of harassment to ensure that students have a comprehensive understanding of the issues before being admitted. Also, that members who are appointed to the Legal Practitioners Disciplinary Tribunal have expertise in dealing with sexual harassment or other forms of trauma, and also that membership of that tribunal be broadened somewhat. And also that all legal professional workplaces consider, adopt and apply as part of their workplace policies good practice principles with respect to appropriate victim-centred procedures and use of non-disclosure agreements. Many of the review's recommendations and findings, I suspect, surprised few in the profession. However, one of the recommendations, I feel certain, did surprise many, and that was in relation to work health and safety. That was a revelation for many lawyers. Now, that might strike you as odd, but for many, they'd never seen it through a work health and safety prism before. While sexual harassment is recognised, it's not specifically referred to in the Work Health and Safety Act. It's recognised by Safe Work SA in this state as a workplace hazard which may cause physical and psychological harm. Of particular interest, I think, to you today was recommendation 2 in the review that specifically referred to the work health and safety aspect and made a recommendation, namely that persons conducting a business or undertaking of a legal nature in the state review and, where necessary, update their policies and procedures, including staff induction manuals, to ensure that they eliminate or minimise, as far as practicable, risks of harm arising from sexual harassment. Now, we know that work health and safety laws impose positive duties on people on PCBUs. It's clear, and we know that workplace sexual harassment gives rise to health and safety risks. I can't speak more firmly and to tell you that this was a revelation to some lawyers, one of life's great ironies, but there you go. I think what piqued the interest in particular of many law firms and those running them was that in a work health and safety context, that an employer must actively and comprehensively manage health and safety risks, and that failure to do so can result in enforcement action, including prosecution. So, put simply, I think some lawyers understood it in these terms. They have to take action, and if they don't, it could cost them. Sad, but true. As we know, employers often fail to take swift and decisive action about sexual harassment because they don't know how to manage it, or they fail to see sexual harassment as an HR issue or a work health and safety issue. And they often focus on personalities and relationships between the perpetrator and the victim. Employers have not, in this state at least, in the legal profession, historically managed sexual harassment through a work health and safety framework. And it seems that it's just generally been considered by nowhere near enough lawyers in the state. Thankfully, that has changed because of the review. We know that there are many benefits to understanding and managing sexual harassment through the Work Health and Safety Framework, including but not limited to, and as shown in the Respect at Work report and in the review, the risks can be profiled based on an industry or profession and what is known about it. And this is good for employers and those with duties and responsibility for ensuring sexual harassment does not occur. And given that the work health and safety laws impose a positive duty on the prevention and minimisation of risk, employers who meet the legal obligations under those laws are more likely to protect themselves from vicarious liability claims under equal opportunity and other laws. The work health and safety approach is importantly good for workers. Outside that approach or that framework, the onus is on a victim to report sexual harassment, and no wonder it's difficult for so many to do so. As you know, most workers feel pretty confident about raising a workplace safety issue, whether it's one that they're exposed to or something they witness. They may report it to their manager or health or safety representative. They also may feel they have a duty to report it. That's because of the strong, well-established and recognisable work health and safety framework. Seeing sexual harassment in this context is new for many, and it will take some time to be embedded in many legal workplaces. However, it's important, and I'd like to report that the review's recommendations, and many of them, have been well received and acted on swiftly. Senior leaders in the profession, from the Attorney General and the Chief Justice down, have shown an impressive determination to turn the ship around. There have been many positive outcomes, and I'll just list some of them briefly. In respect of the conduct of judicial officers, for the first time in this state's history, a judicial conduct panel was established to examine allegations against a magistrate who has been stood down, and the work of that panel is continuing. The Chief Justice invited practitioners who were victims of sexual harassment to contact him directly, and some did. Lawyers who want to maintain their practicing certificates have completed or will shortly complete mandatory continuing professional development training in sexual and other harassment, and respectful workplace behaviours training is underway. Most judicial officers have undergone training on the nature and drivers of the impacts of harassment. The universities have done what they were required to do, and the Attorney General's Department, which is the state's largest employer of lawyers, has implemented programs to educate staff about inappropriate workplace behaviours. And the state's Attorney General has also made it clear that any private sector firms that want government work must demonstrate that they have model policies and procedures. So dealing with lawyers and their hip pockets is always a fairly effective way of getting their interest. So, in conclusion, after a thoughtful and thorough and timely review, some positive and encouraging changes have occurred, and I think that momentum will continue so that cultural changes will be made over time. I'm not so naive as to think that sexual harassment will become a thing of the past. However, I'm confident that with training, improved complaint mechanisms and support, as well as viewing sexual harassment as a work health and safety issue, there is a chance it will reduce. My office will review the progress in 3 years, and will assess changes already made as well as those in train to determine whether safer, more respectful and inclusive legal workplaces have been delivered. I am optimistic and I look forward to completing that review. Thank you.
Thank you so much, Commissioner Jodeen Carney, for finishing on that optimistic and confident note about cultural change around sexual harassment over time.